Hi folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I represent green card holders in federal lawsuits to enforce the Form I-864 Affidavit of Support, and I serve as a consulting expert when the Affidavit of Support is enforced in the context of family law proceedings. Today, the question, does your entitlement to support under the affidavit get reduced if you have received loans or financial gifts from family members? Short answer, no. So basically, here's how it works in the real world of I-864 litigation. When a demand is made against a defendant, most of their energy is typically focused at what has the plaintiff, the green card holder, been using to live off of? Because unless you're dead, you've been relying on some sort of financial benefit to stay alive. Even if that's one of my clients who's living at a domestic abuse shelter and living off of food stamps. If you're alive, you've probably been making use of something to feed yourself and to provide shelter. So sponsors who are defendants in these lawsuits want to focus all of their energy at assessing what it is that the plaintiff has been living off of and whether there's anything there that the sponsor can use as an excuse for not living up to their obligation under the Affidavit of Support. One of the things that sponsors love to argue is that if my client, a I-864 plaintiff, got a loan from their parents or got a gift from their parents or from friends in the community, that that reduces what the Affidavit of Support sponsor is liable for. Now think about how crazy that argument is just on its face. Congress created the Affidavit of Support in 1996 specifically to require Affidavit of Support sponsors. That's the person, if nothing else, who signed the visa petition to bring somebody into the United States. Congress said, look, if you want to bring a family member or a spouse into the United States, that's fine. And part of what that is going to mean for you as the sponsor is that you will be responsible for supporting that person if they need it. So what then happens? Well, usually it's a married couple, they split up, the foreign national, my client, is unemployed and goes to the sponsor and says, remember that contract you signed. I want you to live up to that obligation and provide the financial support that you said you would. And then the sponsor turns around and says, well, I don't have to do that because your mom gave you $1,000 for groceries to use for several months. Well, that's ridiculous because mom isn't the one with a contractual obligation to support the plaintiff. It's the sponsor. The sponsor signed this binding affidavit of support, and the only reason that the sponsored immigrant is going to friends and family members looking for loans or a little bit of gift money is because the sponsor breached their contract and didn't provide the support they were supposed to. So it would be ridiculous if sponsors could get out of their obligation by just backing away from the contract, not doing what they said they would do, because we know at some point the plaintiff, the sponsored immigrant, is going to have to go somewhere to find something to live off of, whether that is a community food bank or shelter or asking friends for a handout. It would be ridiculous if the sponsor gets off the hook because the community steps in to live up to the obligation that the sponsor should have been fulfilling in the first place. And that's the whole reason that Congress created affidavits of support in the first place, because Congress specifically did not want the American tax-paying public to be responsible for supporting recent immigrants when it should instead be the sponsor's obligation. So it would be crazy if a sponsor could say, well, that person is getting food stamps, so I don't have to provide support. No, the whole reason that you had to sign that affidavit in the first place was specifically so that the burden wouldn't fall on the food stamps program and other community benefits. Now, there's a more technical reason why this gift and loan money argument is crazy and simply wrong. And that is because the definition of what constitutes income for purposes of the affidavit is clearly contained in federal regulations. 8 CFR 213A.1 is the definitional section that governs all of the rules pertaining to enforcement of the affidavit. It specifically says in that definitional section what income means. And what does it mean? It means taxable income. So, leaving aside the policy reasons why it's crazy to reduce a sponsor's obligation by loan and gift money, it's inconsistent with the federal regulations. The federal regulations say that we define a sponsor's obligation in terms of the income level of a beneficiary, and when we say income, we are referring to that person's taxable income. So if that person gets a $5,000 loan from mom, is that income? No, it's not income because the loan isn't taxable. What if she gets a $5,000 gift from mom? That also is not taxable because gifts in that amount aren't taxable. So there are both policy level reasons and also technical, into the nitty-gritty of the regulation reasons that the answer is no. Receiving loans and relatively small financial gifts does not reduce a sponsor's obligation. And again, this is a situation that comes up pretty often in affidavit of support litigation because, once again, the person has to live off of something, right? And that was supposed to be the sponsor's money. It was supposed to be that if the plaintiff needs financial support, that comes from the sponsor. And when the sponsor breaches that obligation to the federal government, person sponsored by that contract's got to go somewhere else to try to find a way to get by. And if they manage to get some support from family and friends, that does not mean that the sponsor's off the hook, period. Hope that's helpful. If you have questions about enforcing the affidavit of support, drop them into the comments. If you want a confidential case assessment, feel free to reach out. We offer those free by video all across the country. Take care.